Up here. Good morning, Mr. Long. Hey, can I borrow one of you guys real quick? Mr. Long, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On April 6, 2026, in Harris County, Texas, officers on patrol and observed a suspicious vehicle that was possibly stolen. When officer made a U-turn to investigate the vehicle, two males exited the vehicle and began running. Defendant was advised to stop and get on the ground, but he continued to run. After 25 to 50 yards, defendant was taken into custody.
So he's out of the car. They tell him to stop, but then he runs.
Yes, Your Honor.
Okay. Is there a co-defendant in this case?
There was another individual with him, but they did not catch him.
Got it. Okay. What time of day or night was it?
Your Honor.
Mr. Long, are you here with anyone today? Who are you with? Okay. What about your folks? Who do you live with now? Where's mom now?
It's not clear from the things, Your Honor, and we don't have any discovery in yet.
Yeah. As a condition of your bond, Mr. Long, I'm now ordering you not to hang out with this person that you were in the car, and I'm going to give you a curfew. Nothing good happens for a 17-year-old at 2 a.m. You're ordered to be home from 9 p.m. until 6 a.m. If I find that you're out, I will revoke your bond, put you in jail. This is not a revolving door. I will protect my community at all costs. You are not allowed to use alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. You will be tested 30 days from today. If you test positive, what happens? You and only you hold the keys to that cell. I'm not here to play games. I have enough drama in my life, and we don't need another 17-year-old statistic. So I will do everything in my power to prevent that from happening. You understand me? Tell me what you're doing with your life now. It's now time for you to either get a job or get into full time. But when you have too much time on your hands, you become self-destructive. 17, you've already got a case now. It stops today. Do you understand? You will be back here in 2 weeks, and I want to see what you have done to get a job, either in school full-time, registered in school full-time, or with a job full-time. If nothing of one of those have occurred, it's not going to go well between us. You understand? You were skirting extremely thin ice now. That ice cracks, your butt's going to freeze. Can you appoint a lawyer, please?
Yes, Judge.
Come on.
Right this way.
So test in 30 days.
Yes, Judge.
Bottom of 19, Morris, come on up.
Oh, no weapons. Veronica, please. What was the last name, Sean? Did you hear?
Morris. Yes, sir.
Mr. Morris, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Every time you miss court, we double, triple, quadruple your bond. Your bond is set at $7,502 now. If you miss court again, I will go bananas on your bond. Do you understand?
Yes,
Your case is 3,982 days old. We set cases for trial at 180 days. Take a seat for me in the jury box. Will you please appoint him a lawyer?
All right, next is top of 28, Smith. Come on up.
Over there. I don't want you sitting next to him. Good morning, Mr. Smith. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 6th in Harris County, officers were dispatched and met with the complaining witness who stated that she had been in a dating relationship with the defendant for 15 years and they had recently broken up. Complainant met the defendant, at the defendant's place of work, attempting to get money that he owed her. The defendant struck the complainant on the left side of the face. The complainant stated she felt pain because she had a bad tooth on that side of her face. Officer reviewed surveillance footage, which showed the defendant bringing his hand across from the right side to his left side. Defendant's finger could be seen at the complainant's left cheek.
Mr. Smith, I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection that identifies Ms. Winston as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this order, they can file additional cases against you, and a violation of a protective order is one of the worst cases you can pick up. You are not to have any contact with this person. You understand? You violate this, I will revoke your bond, put you in jail. No more PR bonds for you. You have the ability to hire a lawyer. What do you do? How do you support yourself? Okay. I can have you fill out an application. I need to know how much money you make, and then we'll take a look to see whether you qualify in the jury box. Deputy Williams will give you an application. I'm going to have you sign a reset, and then we'll have you take a sit in the jury box. We're going to get bond conditions created for you to sign. Do not leave until you sign them, and then we'll take a look at your applications.
That's it for now, Judge.
Great.
Thank you.
Oh, yeah. Yeah, but he comes like,
Exactly. They took a hit on that warrant, issue. But the sheriff's office over the weekend on Sunday, they just said all the reasons they got back those things.
where is he now?
We didn't postpone.
How was it made?
So I think he told.
What's the cause number, if you don't mind?
261.
Okay.
397.
That's
Hey, are you ready, Herman? Come on.
So Mr. Silver, for some reason, only one of those two cases are on the docket today. I think we just need the conditions on his motion to adjudicate. We took them in on Dorian
Okay,
on Friday, and then he made it on subsequent to that, and he's here.
got it. Okay, so we'll just do the no contact, no weapons, GPS monitor. Everything will continue as is.
Yes, sir.
Just not to go within 1,000 feet of where she lives or where she works, no weapons, and yeah, no alcohol, no drugs, random testing.
Yes.
Okay.
And just one of the two cases is on the docket.
Don't worry about it. It's not a big deal.
Okay.
Just-
I was saying, we might take care of it today.
Well, that's up to you,
Yeah.
but
We're gonna try to.
Go ahead and sign.
Okay, well, whatever you need, Herm. You just,
So I can reset, you're okay with me
yeah,
resetting
of
it on
course.
Friday?
Yeah, as long as the conditions are entered and he
Absolutely.
signs and,
Okay.
yeah, okay. Elon, what's up? Great to see you. I know. Do you have something with us today?
I do, Mr.
Great.
Guerra, put over the test.
If you look at the stuff on the file, yeah, sure, if you sign.
Probably not.
Council for reset. Is everything in?
They just shared a bunch.
Do you have, can you get the permission to sign? Okay,
Did they give their offer?
Yes.
I'll sign it for you now. And then, I guess just let us know, you know?
He's gone over and take a test, you want me to stick the light on, so I can come back?
It's up, you don't have to, but if it, yeah, it's gonna take a while, but we'll have to address it if, hopefully it's negative. But if it's otherwise, we'll have to address it. So
Council for
just
reset.
pick a day this week that you'd want to come back and then we'll have him come back on that day.
Maybe Thursday morning?
Sure, of course. Yeah, just let Victoria know.
Okay.
Okay, thanks,
Good to see
Elon.
you.
You too, man. Take care.
Like that.
Judge, for the MHA, how much time do you want?
I don't know, I mean, let me see. Tell me about discovery on the harassment case. Are you missing anything?
Barbara is just disclosing some stuff, sharing some stuff.
Yes.
Are you missing anything though?
I believe we're still waiting on the office report.
Thank you.
No, I.
We
Bless
got
you.
some discovery in, that I shared today. I have to look through it to see if we have that in there. I still haven't had the chance to talk to the complainant either. So
Okay,
I want to talk.
so get ready, because I'm not gonna I don't want to hold the MHA open forever. Please, if you don't mind, at least trying to rip it between now and the next setting, 30 days.
Okay. Well,
Yeah.
It's probably Amazon needs one. I don't know if that matters.
Well, it's in,
Instead.
right, I mean, he's got the open,
Correct.
well, no, but he's on bond. The MHA's been filed, so it's on hold regardless.
Okay.
When is it?
man,
May 20th.
Okay, so do it before that day, before May 20th. Yeah, okay.
yeah, because it's already a 2 years, so we can't extend it. So if anything, we'll,
I can extend it another year. I have up to 3 years.
oh, that's fine, okay. Fine, I'm sorry. Well,
Ms. Donaldson,
Herman.
I'm gonna come back.
Oh.
hey, can we talk? Good morning. Is this yours? Any reasonable reconciliation? Because we got the jury, the panel room asking if we want to bring the jurors over now, so. Is he in custody? He's on bond. What's his last name?
Gonzalez.
Gonzalez.
Next to the officer, chief of prison, but I can't prove it, it's not a thing, so. Otherwise, it's just the two officers. I
I didn't hear what you said. What did you?
So the facts of the case, put them into the chief approval, PTI, the chief approves it. But other than that, there's two offers in the case already. I'm certain. Probation.
The other one from way back when, was it just one of those prior to PTIs?
I believe so. It looks like it was just a time surge on that prior one. So,
Do you want to reach out? Who are you talking to?
right now it's Bernadette and Margaret across the hall. But I don't know if their docket has started, so I don't know if she's here.
You want to try to reach out to see if, is that what you're,
I can ask him.
you want to, because I don't want him to go if it's a futile attempt, you know?
Sure.
And then just because we got the jury room blowing up our phone, asking if we want the panel to be brought over. So we need to know.
Can I stay now?
Please. Yeah. Yeah, but just don't take too long, guys.
Council for reset.
Another question for you, Judge. All three.
Oh, under Gonzalez? The two older ones?
Yes.
Okay.
It's just showing on three. So just two.
Why all three?
I'm not sure that's why I held it just to ask.
No, just why I put just the two.
Okay, be mine, this top one right there.
Oh, is that the new one?
Yeah, that's the new one. It's showing Dawn Road.
Got it. Okay. Yeah. All right. So this must be the old one then.
Yeah,
That's the new
one.
one. Got it. Okay, I see. Oh, thanks. Victoria. Vic, can I give you cause number?
Yes.
261 3397.
Yes, Judge.
So let's go ahead and appoint him someone today. Let's ask the lawyer to reach out to Mr. Robinson and let him know that he'll have court on Thursday. And that if he fails to appear on that day, then a warrant issues. Please.
No, that's bad. Yes.
Oh, she.
Is that?
Hey, is Mark Thiessen still in trial? Do you know?
Yesterday is like 1 o'clock.
How far along are they? Is it close?
I think it's the same trial that started it.
It was an intox man.
Started. So we're into week 2.
Okay, thanks.
It is the same trial.
Okay, I can, I'm going to expect for the results. Well, I don't think you have changed what you need to see, you know.
That's when we just moved to Thursday.
Yeah, sure. We'll address it on Thursday. Hey, Sean, any news?
Just taking a look at it right now.
Got it. Okay.
So I love the information. Yeah. What's this going to do?
No, it's. So, sorry. No, there's about.
Hey, hi, Colin. What's up?
Your case is set for trial for April 28th.
Okay,
Normal thing.
We just wanted to let the court know we have reached an agreement and he should be able to complete the agreement by the weekend of 21st to 22nd. It's a DWI education class, 2-day course, 12 hours.
Okay, we're set for trial when?
2028.
Okay, so great. He's got until the 28th to finish.
Okay.
If he's not done, then he gets put to trial that day. Let him know.
Thank you.
Okay, for sure.
Holdings. Come on up.
Hey, ready? What's the word, Thunderbird?
So for the fine PTI, but reduced to lower probation. Sounds like not gonna be resolved, so.
Okay, that's fine. I mean, let's get the jury then. Yeah, okay. We need someone to get the jury. Oh, great, okay. Okay, yeah, yes, all right.
You're free to go. All right. Mine doesn't feel like.
You know, I'm very good at that. Not going to say.
So I had to get such a constant. Yeah.
Hey,
Morning, Judge.
come on up. Just the last name,
Morning.
okay?
We already submitted the PTI application. They've got it. We've reset him so that we can do that and get the TRAS done today.
Okay,
He speaks Dari from Afghanistan. He assists the U.S. military in an operation. I've got a translator here with me
okay.
today.
So we'll send to go do the TRAS with the
Yeah,
translator.
but they, yeah. Okay.
That's,
Because otherwise, I don't know how.
yeah, do it.
It's such
That's
a
good.
part of why you should get a translator.
Sure.
No, you want to get. Yeah.
Hi,
Good morning.
hey, good morning.
We're touching on Yana Williams.
Okay.
She is in custody. We rolled her from last week because you granted her a PR bond. That PR bond was never granted, so she is still in custody. Her
Don't-
PR bond was never put in.
Was it something that we wanted to verify, perhaps family or anything like that, or no?
I'm not sure, Judge.
What do you remember?
So what I have in my notes is that we were hesitant to grant the PR bond. We just need confirmation that she had somewhere to go.
Okay. All right, Judge. I'm so sorry. I thought all of that.
Do you
was
want to
going
just
through.
take a look real quick, see, and then we can release her today?
Yes, I would love to
Just,
do
just to
that.
confirm, I just don't want to release her at the street. That's
And just into meeting
Yeah.
her. I know she had an uncle that she possibly could stay with, but she also expressed some discomfort about her safety in the uncle's home. And I don't know if maybe that's where we're going wrong. If she cannot go to her uncle's house, where do we stand?
That's the question. Where was she gonna go? The street? You know, that's what I don't want to let her.
Or to a shelter, Judge?
What was her last name?
Williams.
Let's see what kind of criminal history she has. Right, this is the one where have I reinstated once before already? We gave her a GOB, failed to appear. She got another person involved, failed to appear. Now she's in custody. Can you ask her where she's gonna go?
Yes, Judge, I'm happy to do that. I can go talk to her. Courtney is in trouble, but I'll get her in there. Thank you.
Yeah, for sure.
Do you solemnly swear for that the information that you provide is like in the history? I want to have your signature for the certificate, and you go inside.
Then I'm gonna leave everything out of there and wait until the 20.
This is your property, usually likely it's just something, if you sleep and then you sleep. What was it? Well, this kind
Mr. Morris.
Yes. So the only selection should be on 5 minutes. Did you want to use the rest of the 5 minutes?
5 minutes, yeah. Ready? So, hey, are these the students? Hi, we're about to start a trial. So I'm probably gonna have to move you guys to the side because we put all the jurors right in the middle. It shouldn't last more than about, maybe, we're just gonna do voir dire today, which should last no more than about 45 minutes to maybe an hour-ish. So we're happy to have you watch, but we put the jurors all right there. I'll have to scatter you to the sides. So you, give me a second and we'll work with the bailiffs to see which side. Hey, Ally. Yeah, of course.
I'm approaching on a different case.
Sure. What's the last name?
Darius Morris.
Okay. Morris.
I was just appointed this morning.
Great.
Would you give me 2 weeks to review the case?
Yes, but I guess let's set it for a hearing.
It looks like he was on probation back in 2014. It looks like y'all had an MAJ hearing around 2015. We go to the court and kind of spin off.
Okay, great. 2 weeks.
Thank you, Judge.
Yeah. He's got bond conditions, no contact with the complaining witness, no weapons and. Okay, yes, ma'am. Hi, Ms. Henry.
Hi, Judge. Mr. Bennett, when I speak to the LD.
Okay.
We wanted him to bring proof of a job.
Yes, how's he doing?
He has some bail proof that he's back working for an elected.
Great. Okay, we'll give you a normal reset then.
Thank you, Judge.
Yes, ma'am. Yeah, can you file no contact, no weapons, please? States, yeah. Ally. Let him know if it takes time for that. Here's mine.
Yes.
As far as you and then you swear.
Yes.
I'm actually the other four last time. Well, I would, but it's fine.
I was told you wanted me to just put the bond.
Say it.
That was when I wanted to just.
Yeah, yeah.
I had entered 25 entries, because it was 2001. They've been years since 2501.
2501, yeah, yeah.
I was 45, it was a bit, I thought it was. Oh, is that different? No, I think this is, I don't think right now. I'm not actually on this, otherwise.
Hey, are you ready to get the jurors? Let's do it. Guys, we're about to start trial.
Thank you so much.
Yeah, in the back. Yeah. Yes, get ready. Come on. Get on it, doggone it.
Yeah.
Oh, check.
Well, Mr. Cooper, I am Mr. Cooper. He has two cases of left almost 1,300 days old because he bond forfeited.
Okay.
Yeah, on the latest case, it's a death. I sent an email proposing to set it up when I got the cost.
So set up for maybe a week? Yeah. Unless you guys are ready to do something. Yeah.
Already, he's already got a institution already and every week.
Okay, great. Yeah. They want to shuffle? Okay.
Yeah.
Hey, did you get a juror list?
Yes, sir.
They're doing a shuffle, so you want to give it back?
They request a shot.
Kim, do you want to talk to me about something before we start?
Thanks for listening to us on.
Hi.
Hey, how are you?
Hey,
Good.
morning.
Good morning.
Just the last name.
HASSAN.
Okay.
She's supposed to self-surrender by today, well, technically yesterday for fraud, and she hasn't had checked with the sergeant there. She hasn't turned herself in.
You got any news?
She's in. She had an attorney in there.
Well, that's,
I know, I get it, I'm just
yeah,
saying.
okay.
She had an attorney down there, to try to get a guard or something like that. That did not happen. She stated, her and her husband stated that they are en route to Virginia.
There's no proof that she could be in China. I have no idea where this person is. They provided no proof that they're even in America. I don't-
So let's do this.
I believe she's in America, she's not.
Like, I have no proof.
I mean, I'm not gonna vote.
I know. So look, I'm gonna revoke it now.
Okay.
If you somehow get before the end of business day today, by 3 o'clock, when that she's turned herself in and he can verify it, then I'm happy to reinstate, but I'm not gonna hope, wish and pray and just, she's supposed to do it yesterday.
Yes.
And we're here the next day. So yeah, it gets revoked.
Thank you.
I'm just.
Just let me know. Yeah, just let me know. So you saw her son? Yeah, if you can revoke it instead of a 0. Top of page 13. Zero. It's a fugitive case.
Waited appearance. Sorry about it.
No. I've been shocked.
You can move the new list now. Yeah, let's get them in. All right, guys, we're about to be in trial. We're going on the record. Do not talk. If you need to talk, if you need to use your phone, please go outside.
Yeah, it was 0.
Yes.
Okay, hey, state and defense, you want to get your copies of the juror list? And then, hey, before, Ramona, are you ready? Okay. Ms. Donaldson, can I talk to you real quick? I'm gonna go on the record, okay? You ready? All right, we are on the record in cause number, good job. State of Texas versus Alejandro Gonzalez. Today's date is April 14th, one day prior to tax day. It is approximately 10:06 in the morning. Will you guys please announce yourselves for purpose of the record? State first, please.
State is Margaret Odunzi, Margaret, last name OduNC.
Barbara Knockby for the state.
And Sean Baldwin for the state.
Defense.
Maricia, Marecia Donaldson, for Mr. Gonzalez.
Kiana, Kyanna, Sykes, are also from Mr. Gonzalez.
Okay, so I'm bringing you up here now. We're about to bring the jury in for voir dire. Or is there anything that you guys want to talk about prior to starting voir dire? State.
No.
Any motions, anything that you need to talk about? Okay, defense.
Other than our motion in limine, Judge, no, we do have a motion in limine filed. The state did notice an extraneous yesterday of all of his prior offenses, including the prior conviction for DWI, so we would just like that on the record. That no mention of the prior DWI during field innocence.
Obviously, no, you know,
Sure, Judge.
okay, sure. Yeah, I'll grant that motion in limine. Is there anything else that you guys have that you want to address?
Nothing from defense, Judge.
Got it. Okay, great. So they're going to start bringing the jury in and let's get started. I'm going to give you guys each 20 minutes per side for voir dire. And then after that, if anybody has any issues, we can bring them up and talk to them individually and try to, you know, get the jury. We get quite a bit more just in case. Okay, so we'll usually have around 35 jurors just in case. Okay.
Do
Okay.
you have a new jury packet, Judge?
Yes. Here, we'll have it for you now. Yeah.
Thank you.
Okay.
Thank you, Judge.
All right. Loose shred, right?
Yes, yes.
Oh, yeah.
Thank you.
Thank you. Yeah, come on, bring it.
All right, for the jury.
All present and accounted for? Okay, everybody, please be seated. Good morning, ladies and gentlemen. Good morning. Good morning, ladies and gentlemen. Right, awesome, great. What a great cross section. Fantastic. You need to really give yourself a pat on the back. You know that we live in a city of what, 2.5 million people? 3 to 5% of the people who are called upon for jury service actually come out and perform their civic duty. It's an abysmal, I know, it's crazy. I'm with you. You know, it's shocking how people just don't participate. And I don't think that people really get of how important an aspect, a fundamental aspect of our life, jury service is. You know, without you guys, it would be complete chaos. It would be anarchy, like it was back, you know, in 1700s and 1600s, where you'd have the lords and serfs, and yeah, it'd be complete chaos. So thank you so much for coming. My name is David Fleischer. I'm the judge here in County Criminal Court at Law Number 5. I don't know how much experience you have with the court and the criminal system, so I'm going to go from the very beginning, not from very, but you know, somewhat, to give you guys perspective, because that's what this is all about. We are here because of a criminal case. What is a crime? What is what? Well, there are two types of charges that someone can face when they're faced with a criminal accusation. One is a felony and one is a misdemeanor. Those are the two types that we have here in Texas. Now, within those two, we have subclasses because there's all different types of charges. So there are serious felonies, less serious felonies, and then there are misdemeanors. What is the difference? Anything where you're facing a year or more that is a felony. Anything a year and under, 365 days and under, that is a misdemeanor. We're not going to talk about felonies because this is a misdemeanor court. Here, we are one of 16 county criminal courts here in Harris County. We, in this building, I am one of 16, we only handle Class A and Class B misdemeanors. So those are anything that's punishable by a Class B is up to 180 days in jail and or a $2,000 fine. And a Class A misdemeanor, which is the worst of the misdemeanors, where you're facing up to a year in jail and or a $4,000 fine. The Class C, which you probably all have heard of, like speeding tickets, traffic tickets, maybe, maybe like an eviction or something of this nature. Those guys are handled either in municipal court or in one of the justice of the peaces. Harris County is so big, you can be in Katy and then go all the way to, what is it, Webster, give or take, and you're still in Harris County. It's huge. So municipal courts here in downtown, and the one that everybody knows on Lubbock, it's just not enough to satisfy all the needs of how big our county is. So that's why they have justice of the peaces all over Harris County. Depending on where you might get a ticket, that's where you will hit. Like if you get, toward like I-10 and Bunker Hill, you might get the JP on Dairy Ashford, give or take. So anyways, those in Class C offenses are only punishable by up to a $500 fine. That is the difference of what we are facing here as far as criminal charges are concerned. Here, as you may very well see, that we have a misdemeanor trial going on. I don't think that anybody disagrees with the law. Everybody agrees with the law. What the difference is how it's interpreted. Perspective is just about everything, and perception is reality, my friends. What we're asking you to do, no one is asking you to split the atom. No one is asking you to do Pythagorean's theorem. We're not asking you to do any serious equations or math or, we want you to make a judgment call. That's all we are asking you to do. You will hear evidence. You might see evidence. Your intuition will serve you best. All we are literally asking you to do is sit, listen, and make a judgment call at the end. This trial will take 2 days, today and tomorrow. Is there anyone here that cannot be here tomorrow for one reason? Not just you don't want to be here. I know that you don't want to be here. I don't want to be here either. I'd rather be, do you have plane tickets or some kind of, you are juror number 10? Juror 11. Okay. Is that something that you can?
Just tomorrow, one day.
Is there anyone else that cannot be here tomorrow for a serious reason? Just not that they don't want to be here, because you're juror number
6.
Okay.
I'm leading a parent meeting.
I'm sorry, say that again?
I'm leading a meeting from 8 to 9:30. And I'm the only one.
Okay. Sir,
I'm a business owner and I'll be out of town tomorrow.
you're what?
Business owner and I'll be out of town tomorrow.
Okay. Is there anyone else that can't be here tomorrow?
I'm sorry, was there again, juror number?
Yeah, that was juror 17. 30.
Yes, sir. I have to pick up my medical marijuana prescription tomorrow for a disability that I have.
Okay.
Medical reasons.
Can that be done later in the day?
No, sir, the dispensaries are only open, I believe, between like 11 to 5 or something like that. I have to take it 3 times a day.
Okay. Is there anyone here that doesn't speak or understand English very well? Anyone? It's okay if you don't. We just don't want you to get impaneled and then, oh, by the way, I can't. Anyone not speak or understand English? Okay. What is going to happen now is both sides are going to start asking you questions to determine whether you would be a good juror for this case. They're going to get into history, they're going to get into the law, they're going to ask relatively personal questions. I don't think they're going to get too personal, but they're nevertheless going to ask you, because not every juror is great for every single case. We recognize that. And because that's why we have this jury selection. It's called voir dire, to determine who is a good candidate and who may not be the best candidate. And it's okay, but remember, all we want you to do, sit and just make a judgment call. State, would you please raise to announce yourselves?
My name is Sean McLaughlin, the state of Texas.
Does anybody recognize? Oh, sorry. Go ahead, please.
I'm Carl Knopfler, the state of Texas.
Hi, I'm Margaret Benzie, state of Texas.
Does anybody recognize them at all? No? Okay, please be seated. Defense.
Sorry, Donaldson for the defense. Kiana Sykes, also for the defense.
Anybody recognize? No? Okay, you may be seated. Okay, state, you have 20 minutes. Please.
Thank you, Judge.
The floor is yours.
May I adjust the monitor?
Yes, of course.
Good morning, everyone. Like I said, my name is Sean McLaughlin. I'm here on behalf of the state of Texas in this case. Who here's been on the first stage? Great game. It's a little awkward. Yeah, welcome to your first date. Gonna be a little awkward for a little bit. I get 20 minutes to talk to you, get to know you. But before we get started, it's very important that you guys all know there's no such thing as a wrong answer. The key to jury selection is talking. The more I know about you and how you feel, the more I get to make decisions, and the defense will get to make a decision on who gets on this panel, right? There's not gonna be a bouncer. Deputies aren't gonna carry you out. The key is talking. So, like I said, myself and Ms. Knopfler, we represent the state of Texas in the case against.
I just want them to know. Defense counsel.
This is a driving while intoxicated case. Now, what does driving while intoxicated mean under the law? These are a list of elements that we have to prove as the state to find someone guilty of driving while intoxicated. And these can just be thought of like a checklist in your mind. Did you do that? Did you show me that? All right. On or about July 25th, 2025, in Harris County, the defendant, Alejandro Gonzalez, did operate a motor vehicle in a public place while intoxicated. So, let's talk about how we have to prove these things to you in this case. The burden of proof for a case like this is what's called beyond a reasonable doubt. Now, it's a bit of a trick question because there is no definition of what beyond a reasonable doubt means. We do know that the legislature never defined it, but we do know what it is not. Beyond a reasonable doubt, that standard that we prove each element to you by is not beyond all doubt. It's not 100% certain, and it's not beyond a shadow of doubt. And most importantly, it's not impossible to meet. It's a very high burden, as it should be. But it's not impossible to meet, and it's met in thousands of courthouses across the US, and it's met in this building every day. So, what does beyond a reasonable doubt look like? Juror number 3. If I told you that this is a puzzle of a cherry red Mazda RX-8, have I proven that to you beyond a reasonable doubt?
No.
No. Right? No. You got 3 puzzle pieces. Right? That'd be crazy. Now, juror number 5. If I told you now that this is a puzzle of a cherry red Mazda RX-8, have I proven that to you beyond a reasonable doubt?
Yeah.
Right. Yeah. There's a couple puzzle pieces missing, but you get the picture. You see it's all there. You even see RX-8, specific model. And that's the key with beyond a reasonable doubt. It's not 100% certainty, like I said. It's not every single piece of the puzzle. What we have to do as a state is prove to you enough puzzle pieces for you to make sure that you get the picture. When you're building a puzzle, you're asking yourself, what's this an image of? When you're listening to a case of a juror, you're taking in evidence and puzzle pieces and asking, did this happen? Very similar. So, puzzle pieces that you'll see in the case of the DWI oftentimes revolve around intoxication. So what are some signs of intoxication? Anyone, give me some. Slurred speech, what was your number, I'm sorry? Your number 25, thank you, yeah, slurred speech. Anything else? I'm sorry? Yeah, there you go, that's a good one. What about, number 14, what are some other signs of someone might be intoxicated? The test, that's a great one, yeah, we'll get into that later. Journal 16, any other sign of intoxication? Very glossy eyes, absolutely. Slurred speech, very glossy eyes. Now, journal 25, when you said slurred speech, think of someone in your head and they're intoxicated. Is that someone that you know personally? No, right? But you can still tell that they're a little intoxicated in your head when you're picturing them. And that's because the law doesn't require you to know what someone's baseline normal is. It's knowing what a reasonable person's normal is, so you can tell intoxication. Now, you're number 6, or no, sorry. Think about someone that you know and they're intoxicated. You got it? Yeah. What are some things that you're thinking of that you can tell they're intoxicated?
Stumbling.
Right, stumbling, yeah, can't keep their balance, it's a good one. Now, when you think of that, do you have a portable breath test for them to blow into to know if they're intoxicated? No, because when you know someone's normal, you can also tell when they're intoxicated. It's about using the puzzle pieces of sign. Yes,
What if the person has a medical condition like Bell's palsy, which kind of mimics the signs of intoxication, but they're not intoxicated? How would you know if you don't know that they're disabled? And that also looks like drunkenness, but it's not.
that's a good question. So without getting into any kind of facts of a certain case or anything like that, those are things that can come up in speaking with officers or whatever else that might be addressed a certain way. But back to the other signs that you would see, we've seen red glossy eyes, some stumbling, some slurred speech. Now, under the law, intoxicated can be proven to you in 3 different ways. Doesn't have to be all 3. Doesn't have to be 2 out of 3. It's just one of these 3 ways to show the defendant is intoxicated. That first one is not having the normal use of the mental faculties due to the introduction of alcohol or drugs, or not having the normal use of physical faculties due to the introduction of drugs or alcohol. Or the third one, and this is the poster child that everyone thinks about, having a blood alcohol concentration of 0.08 or higher at the time of driving. Now, juror number 2. What are some mental faculties that we typically use when we're driving?
Looking at the traffic around you, see if you're gonna hit someone.
Absolutely, absolutely. Anyone else agree with juror number 2, something like that? Anyone else have any other ideas of what a mental faculty could look like when we're driving? Yes, you're number 12, yes.
Okay.
Right, yeah, following the rules of the road, absolutely. Anyone else? Okay, those are great. So, having known that those mental faculties are important, steering, things like that, controlling how your car is moving, what are some typical things of physical faculties that we use? Yes, go ahead, your car, sorry. 20. Your 20, yes. Reaction time, absolutely, great. Hitting brakes, right? Anyone else? Well, who agrees with your number 20? Right, absolutely. Anyone else have any ideas of physical faculties, what those look like? Fine motor skills. Yes, juror number 18, fine motor skills, absolutely. So, who here would require me to show you a test resulting in 0.0 or higher, rather than the other 2 options? Yes, can I see your juror cards?
Yes, 30.
Juror number 30, yes, and juror number 5. Anyone else? Juror number 22, number 33, yes. Ed, what was your number? Number 15 and number 7. Juror number 31 as well. Okay, so let's start with juror number 5. Juror number 5. So if I'm able to prove to you beyond a reasonable doubt that someone has lost the normal use of their mental faculties due to the introduction of drugs or alcohol, or the normal use of their physical faculties due to the introduction of drugs or alcohol, but I haven't given you a blood test or a breath test, would you be able to find someone guilty?
It would be hard, I think.
It would be hard, I think. Okay, absolutely. So, but for something like this, we're gonna need a yes, I could, or no, I could not kind of situation.
I said no.
No, you did not. Okay, so you raised my burden to.
No. Okay, well, hold on. Let's be fair. Hold on. So understand, with the advent of technology, we can do so many new things. We can go to the moon. You can build a robot that can race and beat someone in a race. Same thing with DWIs. 50 years ago, you didn't have blood tests, you didn't have breath tests, you didn't have field sobriety tests, you didn't have nothing. But it still was an issue. More and more, the older this generation gets, the more smart, the more things they devise, they have. So remember, these things are used as aids, not required. For example, when you see someone, if they are in a complete and utter state that you know, it doesn't take a rocket scientist, right? Use your common sense. Sometimes you may have something, sometimes you may not. Sometimes you may have a video where someone is just stumbling and just this, they vomited, urinated. It's like, it really, just use your common sense and it will help. Like I said, your intuition will serve you best.
Right. So saying yes, during ritual.
So kind of about DWI, that include just drunkenness or is that using drugs, could that also be tied in with that piece of drugs that could include the charge of one?
Great question. Absolutely. So the term intoxicated under the law for a driving while intoxicated charge can be due to the introduction of alcohol or drugs. So it doesn't have to be just one or the other. It could be both. It could be only one. It could be alcohol. It could be drugs. So now, having gone through some of these faculties and it says here, it's trying to understand why the law is the way that it is. I'm going to walk through a hypothetical here. So let's say juror number 7. Let's say that you and I have had a great conversation during this jury selection, and unfortunately for me, unfortunately for you, you are not chosen for this jury, and you are so excited. You get to go out of the building, straight to the jury parking lot, get in your car, go home. And this is what you see when you turn into your neighborhood. Now, juror number 7, what's probably following after that ball?
Child.
A child, right? Now, having gone straight from here to home, do you think that you have a good reaction time to stop?
Yes.
Absolutely. Now, let's change up a little bit. Juror number 9. Let's say that you and I have had a great conversation and you don't end up on the panel, but you are so excited and it's brunch time. Maybe there's an mimosa involved. And you go down the street and you have a drink or two and then have the rest of your day off and you're going home and that same situation happens. Do you think that you would be able to stop just as fast as juror number 7?
No,
Probably not. Why?
because I drink and.
Absolutely. And that's why the law is the way that it is, because it's a difference between a child learning a lesson and possibly a child needing the hospital treatment. So going into that, for the intoxication, what we've been talking about, everyone knows that the legal limit is 0.08, right? It doesn't matter how much you drink, though, tolerance looks different depending on who it is. And that's why it's important to know things that we as the state do not have to prove to you are how many drinks the defendant had, if they intended to drive that night, or whether he was falling down drunk in a urinal or something. None of that proves intoxication under the elements of the law. That's why it's not required of us. So, having broken down intoxication a lot here, and knowing that there are 3 ways to prove it, kind of going back to what we talked about, is there anyone here who would raise my burden and require me to bring you a breath or a blood test? Yes, juror number 30. Yes, juror number 30. Okay. And so you would require.
It's kind of hard to argue with that. You can argue, oh, they were stumbling, oh, well, I'm just clumsy. Or you smelled alcohol, well, I work at a bar and it was spilled on me, or someone spilled a drink on me. They're swerving, oh, well, I just, I had anxiety. It's kind of hard to argue with the facts, with the blood tests.
Absolutely. Everyone's, there's not a bouncer kicking around, right? Any answers, good answer. Who agrees with juror number 30? Yeah, can you raise up the cards for me, just so I can get the numbers? Juror number 14, number 15, number 5. Okay, so juror number 5. Back to what we were talking about earlier. If I was able to prove to you beyond a reasonable doubt the loss of physical or mental faculties through the introduction of drugs or alcohol, would you raise my burden and require you to bring in a brother's blood test?
I don't know if I understand exactly. If somebody has lost, some coordination, are they legally drunk if they're below 0.08?
Right,
So
so
what happens if you get stopped and they go, hey, have you had some drink? Yeah, I had a drink, and then you have a blood test and you're under the limit. Are you still intoxicated?
that's a great question. So that's why there are three ways. Intoxication doesn't have to be by a point of weight. It can be by the other two. And so that's why I'm asking if I'm able to prove to you that someone was intoxicated by losing the normal use of their mental faculties or their physical faculties beyond a reasonable doubt, but I don't show you that number, that blood or breath test, would you be able to find them guilty?
It's the word of an officer.
Without getting into kind of case specifics, it could be.
Okay. I don't know if I understand, but if your blood alcohol is below 0.08, are you legally drunk?
So I understand. That would be something that we prove to you based on one of those three definitions, right? One way to prove it would be above 0.08.
Right.
Another way to prove it would be by the faculties, the mental faculties being drawn, regardless of what your blood alcohol is.
Okay.
Another one would be proving the physical faculties being drawn, regardless of what blood alcohol is. So, yes,
I
sir.
have a question, sorry, juror number 3. So if you don't have a blood test and you have to go on the other two, is it just the officer who did the arrest, is it their word against theirs? It seems kind of iffy if they're referring to the court. How fair is that to the person driving? Are they, I don't know, I don't drink, so I don't really care, but I'm just curious as to like, how would they know? Like, what if the officer, just doesn't like the person, or if it's bias, or how do you guard against that? How do you?
With jurors, that's why we have you. Aren't you the best person? I know that you wouldn't hit a dispensary, but aren't you the best person to sit here, listen to all the evidence and make a judgment call? You don't need a blood test. It doesn't have to be alcohol. If you take too much NyQuil, what does NyQuil do to you?
It just makes you fall asleep.
Right. It doesn't have to be alcohol. It can be anything that causes you to lose the normal use of your mental and or physical faculties. We don't need a blood test. We don't need a breath test. You don't need Jesus telling you this or that. No.
Can I just say, I feel like you're leading the jurors, and it just kind of feels weird to me right now, like it feels like you, as the judge, are trying to tell us, like, you don't need the facts, you don't need this, but what if I do?
I'm answering the question as far as he had a concern as to blood tests, as far as in conjunction with the normal use of mental or physical faculties. And what I'm trying to show you is that there are other ways, not just this way or that way, and not to focus. So many people nowadays want to quantify everything, put a number on this and put a number on that. And the law is not like that. There are so many other things that you have to consider. So the job of a juror is to listen to all the evidence, see what's out there, and then make a judgment call. You are supposed to keep an open mind, and we have 6 independent people to sit and make that judgment call because everybody has a different life experience. And so that's why we have a huge cross section here to come and make that judgment call.
So, juror number 15. Now, I want to go back to this for you and even 14. So let's start with 15. Knowing that there are 3 ways to prove intoxication, would you require me to raise my burden and show you a blood test or drug test? Sorry.
I would, because I've been in a situation where I go out to dance clubs, and dance all night, and I'm drinking, and I was picked out one time by a bouncer, and I was just simply like squatting and stretching my legs, and losing my balance a little bit, and he thought I was too drunk to be there, and so he kicked me out. I understood it was not, and, I knew it was not like too inebriated. Right. So now just change that person up, whatever, a police officer, and he's like, oh, so you're too intoxicated to drive, or and they don't want to listen to you. Now we're gonna report, jail thousands of dollars and so forth, and, well, sure, yeah, I was exhibiting certain behavior, and sure, I had alcohol in my system, but I wasn't really too drunk. I mean, I just exhibited some behaviors, but I was stretching my legs, complete dancing, so it's like, I can imagine those kind of scenarios, not the details of this case. I am very well aware that, of course, I know what it's like to observe somebody who looks very drunk, and you can say it's certainty based on their behavior. Yeah, they're too drunk to drink. I'm aware of that, but you're asking me to make a judgment call right now, knowing nothing about this case. I have to put myself in that position and say, well, what is that for me right there in that situation in the dance club when I got kicked out? If that was a police officer arresting me, and that's what I was judging on today, that would be very hard if you want to judge only by this and say, like, well, can you get behavior or mental or a test? I'm like, you get a test, because I was innocent in that case. So I have to put myself in that place.
Absolutely. And I will get to hear, yes, I'm too.
If I was high as a kite on LSD, would I both 0.08 breathalyzer test?
That's a good question. And in that hypothetical scenario, there could be other ways to prove intoxication besides a test. It could be the other type.
Right, so I could be intoxicated by something else
Yes.
and we passed the test.
Okay, blood alcohol test.
Yeah, right.
So, Journal 14, I don't think I got a chance to speak to you there. Would you require me to record?
After listening to talk, I would be more open to.
Oh, absolutely, yeah. Now, hearing all that and knowing about the different tests and different ways to prove intoxication, how do we get there? What kind of evidence do you expect to see in a trial like this? Anyone? I'm sorry? The video, absolutely. Anything else? Yes. Hearing from the officer, absolutely. That's a good one. That's a good one. Yeah, so there's different kinds. There's a lot of different things that we can see, but something that a lot of people need to remember is that while there's video and there's body cam and there's other physical evidence, there's also testimony. Testimony are words that you hear from them on the stand, those witnesses, and that is evidence. You get to weigh that in your consideration of whether we hit those elements, that checklist. Testimony is allowable. Testimony is critical. So, who do we typically hear from to get testimony? We said the officer was one. Who else do we typically hear from in trials in general as witnesses? I'm sorry?
The defendants.
Right, so that is not female, they don't have to. So that's anyone else? I mean, you might be hearing from nurses or anything like that. I'm sorry? If there were any passages, absolutely. So the witnesses, right? You got testimony. A lot of people, or some people might think that, a officer like Rudenberg was talking about earlier, an officer in front of the court, they know the law best, they're doing that all the time. So maybe they start out ahead in my credibility way. Is there anyone that feels like that?
They're also they're not exempt from having biases and showing biases as well, whether, that's just a human thing.
Yes, they're in before.
I feel like law enforcement is. I don't have respect for them. I don't believe they often make laws arresting in this case. So there's like, either that I did go through research training, we got into properly identify drivers that are under the influence. So, it's not common to speak up, just arrest someone because they think they're drunk.
Right.
At least from my experience, a lot of person.
I completely understand. Thank you, Journal 34. Anyone agree with Journal 34? Yeah, you're number 5, you're number 18, 17, thank you for agreeing. Now, what you can base your credibility on, or judge their credibility on, is training, education, and experience. So can we all agree to give those 3 things the credibility weight that they deserve? All right.
2 minutes.
Thank you, Judge. Now, this is Sarah. Sarah, my friend, talks. She's great. And Sarah talks about what kind of evidence we see, direct or circumstantial. You're number 3. Who do you think for that happens? Culprit? Yeah, right, there's something everywhere, there's a guilty look on her face. So, but we didn't see Star, Eric Couch. Yeah, now, during the great life, we'll do that, my next door neighbor in my apartment, Joe, walked in Forest House and put a biscuit on the thing, started sitting there. Is that reasonable? Absolutely, and that's what circumstantial evidence is all about, it's the common sense evidence. It's what asks you to draw the line and connect the dots. You'll see that throughout the trial, those are the puzzle pieces. Now, with a little bit of limited time left, I just want to ask everyone how law enforcement in the community, just by a show of hands, who thinks that it's cool? Yeah, absolutely. Okay, 4, they're doing great. Oh. Yeah.
Have them raise their jury cards.
Well, you're talking about individual officers, you're talking about. So I can base that opinion on the availability of response time.
Absolutely, yes, sir. Yes, sir.
They don't really get anything for comparison.
Yes.
I'm sorry, say that again.
They don't really get comparison.
Now, another question I'd like to ask is, how important is it to you that we prosecute these kind of cases? Who's it for that it's very important to handle these cases and prosecute them? Raise your card. All right, turn number 5, turn number 10, full second rep. Okay, all right, third rep 2.
Time.
Thank you, Judge. Thank you, everyone. I look forward to that case.
Good morning. So again, my name is Mauricia, my co-counsel is Ms. South, and we represent Mr. Alabama from Docket. I'm gonna tell you a secret. The easiest way to end up on a jury is to not talk, right? Because if you don't talk, you don't know anything about you. So with that, I'll go ahead and jump right into it. When you flip up a light switch, jury number 8, what happens?
It's fine.
And then jury number 22, when you flip a light switch off, what happens?
You said when you turn the lights switch off, yeah.
Yeah. Okay, so, okay, got it. So when you flip it on, up, it comes on, and if you flip it down, it goes off. So we know for sure the light is either on or off, right? There's no in between. So when we ask you a question, we want you to give us a yes or no. Sometimes you might feel like, I think so, or maybe. But in order to pick a fair jury for the case, we need to know your true feeling. So when we ask you a question, if you feel compelled to say, I think so, go ahead and flip that light switch on and say yes. Or flip it off and say, no, we got that. All right, cool. So can anybody tell me what a charging instrument is? A charging instrument, do anybody know what it is? Not necessarily like a cord, but let me help y'all out. So it's a sheet of paper just saying, hey, I think this person did something, right? It's not evidence, it can't be used against our client as evidence. It's just basically an allegation, right? We don't know if it's true or if it's not true. But who here says, I understand what a charging instrument is now. I know that I can't use it against your client. But the fact that he's sitting in here and I have to be here listening to you right now, he must have done something. If that's you, go ahead and raise your jury card. Yeah, good deal. And let's talk about the state's burden. So, as Sean told you, the state's burden is beyond reasonable doubt. So after hearing the evidence, if you feel like, he might be guilty, what should your verdict be, jury number 9? He might be guilty. I would like to see the evidence. Right, so after seeing, I'm sorry, it says you have to see the evidence. So after seeing the evidence, you're like, maybe he's guilty. What should your verdict be? No, and that's all of this. Okay. Anybody disagree with your number 9?
Maybe what you said, if it might, you think you might be guilty?
Right, what should your verdict be?
I think you should not should be quiet, you know, if you might,
But we
unless
don't
you
get
feel
to be
like.
quiet, just you're-
Well, I understand, but if you think he might, but if that being quiet, then you might not.
Right, so
That's
is
what I'll
it guilty
say.
or is it not? guilty?
I would say not guilty.
Okay, does anybody disagree with juror number 30? Juror number 30, I know you by heart.
Say, I kind of disagree because there's a reasonableness that you have, there's a reasonable standard. So you don't have to be 100%.
Right,
And if it's beyond a reasonable doubt, or a reasonable person who believes, then, oh, yeah, I would find it guilty.
right, so it is beyond a reasonable doubt to give.
Yeah,
Right.
well, that's who I vote for. I mean, it's the only vote I have.
Right, understood. Juror number 20, that's how
I
you're.
was just gonna say, I think the difficulty is might be so subjective without actually hearing the evidence. It's hard to say like what might mean, you know, like.
Right, but
Am I
what
saying
is
it might, right, am I saying that he might have, you know, a reasonable doubt, that's not a part.
Well, that's a decision that you would have to make as a
Exactly.
juror.
Right.
I saw a card back here, juror number 35.
I was gonna say, I thought reasonable doubt meant that, so if you have doubt, you shouldn't convict anybody based on doubt. So
Right,
that's why you would almost say not guilty because you have doubt.
right,
It's
and
like being not sure,
You're not sure.
not sure, you don't want somebody writing on, like, you don't make a decision.
one second, guys. Love that y'all are engaging, but, this lovely lady over here is taking out everything that you say, so make sure you raise your card so that she can forget and to try not to talk about something else talking, because they know every 5 seconds, okay? But I love the conversation. All right, so let's talk about, we talked about the state version, let's talk about the technicalities. So one of the elements that the state has to prove is that the offense happened in Harris County, right? Now, obviously, we all live in Harris County because we're here, right? So say for instance, juror number 1 slaps juror number 5 and says, I'm juror number 1. I slapped juror number 5 because I didn't like the color shirt that they were wearing, right? We take this case to trial, and the state does not prove that it happened in Harris County. What is your verdict going to be, juror number 7?
If it didn't happen in the county, then not guilty.
Okay, does anybody disagree with juror number 7?
If I saw it.
No matter what you saw, you say you gotta prove it, right? They have to prove every element beyond a reasonable doubt. So regardless if you know that it happened in Harris County, the state has to bring you some evidence and prove that it happened in Harris County. And if they do not do that, then they have not met every element beyond a reasonable doubt. Do we understand that? Okay, so I see some confused faces like, after hearing that, who was like, I know what the law says, but I cannot not convict on the technicality. If that's you, go ahead and raise your hand.
Sorry.
So if you're saying, like, I understand they have to prove everything is under the about, but if they tell me that if they don't bring evidence saying that it happened in Harris County, and they don't prove that element, I'm okay with still convicting because I saw it on video. Number 5, number 19, 22, 31, and 30. That's a good way. Has anyone here ever been a victim of a drunk driver? Juror number 17. Would that affect your ability to be fair in this case? Can you give a verbal?
Yes, I mean, no.
Okay, so no, it would not affect your ability. All right, I saw another card. Juror number 18. Would that affect your ability to be fair in this type of case?
No.
I saw a card over here, juror number 25. Would that affect your ability? I need a verbal.
No.
Thank you. Do I have any police officers in the room? All right, so the law says that if you're an officer,
Yeah.
okay, sure, yeah, we can call you up if you like. Okay, so if the law says that everybody has to start with the same level of credibility. When the state asks about, he asked a question about officers, and somebody said that they expect that an officer doesn't make false arrests and things like that. So in response to that, my question is, if you understand that officers have to start with the same amount of credibility as everybody else in this room, is there anybody who says, I believe that officers have a higher level of credibility than the average person?
I'm sorry, that 30.
Okay, hold on. All right, and y'all understand before you raise your cards that the priest, the officer, the prostitute, everybody started at the same level, right? We understand that. So the people that are raising their cards, you're saying, I understand that they should start with the same level of credibility, but I think that an officer is at a higher, I hold their credibility at a higher standard.
I do, because of the training experience. And, you know, they're trained to do this job, so I hold them to a higher level of credibility.
And you give their testimony more weight than you would give anybody else?
I would give their testimony the same weight as another officer that's had the same level of training experience.
What about the same level of credibility of the person sitting next to you?
Depends on their experience and training.
Okay. Numbers,
Does that make sense?
it does make sense. Is there anybody that agree on with you? Is there anybody?
They carry firearms. They know how to drive under hazardous conditions. They receive a higher level of training at recognizing the signs and symptoms. Those first two categories, the three, they're trained to look at this.
And so when you say signs and symptoms, what are you referring to?
The mental and physical aspects of the driving.
Do you know what a person looks like when they're drunk?
I do. I'm a defensive driving instructor and safety professional.
Okay, can you carry a firearm?
I do not carry one. I do own them.
Okay. And so if you were testifying, would you want someone to give you that same level of credibility based on your knowledge? Same credibility as an officer?
When it comes to driving under the influence,
Just based on your observation. You said you know what a person looks like in their drunk.
yeah, I'm not to the level of an officer, but
Okay.
but I've done a lot of training and studies in my profession to recognize that, so that people don't get hurt in the workplace.
Understood.
It has to do more with impairment than it does with under the influence. I don't really draw a line at impairment and influence. If it's not safe for the driver, shouldn't be driving.
Right. Juror number 16.
So I want to be clear when I say this, I'm only talking about credibility, I'm not talking about whether we feel like we're better than somebody else. Credibility well is, because for this job, I do a polygraph test, I do a background investigation, so I'm trying to say. So there's certain stuff that we have to meet before we even get to match. So for that instance, yes.
Okay, and then.
Isn't polygraph pseudoscience? Is it not polygraph not admissible in court? Why did the cops still use it, guy?
Well, I don't know. It's not admissible in court. I don't know why they use it. They might be their preference. But.
Again, it's just credibility, we're not talking about.
So then I was there, well, you're number 16, I'm under 50 bucks. Do you know any officer that's ever lied?
Of course.
Okay, so then I think it's fair to assume that officers could lie, right? And that's why everybody should start with the same level of credibility. All right, is there anybody that disagrees with that? Juror number 34. Juror number 10, I know, you have made it very clear. Yeah.
It's just not my.
Understood. Understood. So that was your number 10, and then your number 34, that's the recent party. Yeah, anybody else? Your number 5. Okay. So let's talk about the Fifth Amendment. Do you know what the Fifth Amendment is? Your number 1. No? Anybody want to help your number 1 out?
Right to remain silent.
Right. So everybody has a right to remain silent. So if our client decided not to testify for whatever reason, maybe because he's nervous, or he doesn't like to talk in front of people, or we advise him not to testify, you can't hold that against him, right? Do we all understand that? Is there anybody here who said, like, I understand that we have a Fifth Amendment right not to self-incriminate, or we don't have to testify, but if it were me and I was being charged with something that I didn't do, I would want my chance to tell my story. Does anybody feel like jury number 30? Okay, jury number 5, and jury number 7. Okay, hold the cards up, I'll go around my line. Jury number 5, 7, 20, 21, 22, 30, 32, 33. So let me just ask a follow-up question. So are you saying that although the law does not require, if he chooses not to testify, you will hold that against him? If it's still against, put your card. 5, 7, and 30.
Suspicious.
You know, suspicious? Well, I don't like talking in front of people. I'm just letting people tell. I got you. All right, has anyone ever gone to dinner and had a beer? A wine, cocktail, don't worry about your nose, you're not working right now. Your car doesn't take it, that's you. Okay, jury number 32, why did you drive?
I didn't say I drove, I said I had a beer at dinner.
Okay, well. You.
Circumstantial.
All right, has anybody ever went to dinner and had a drink and then drove? Y'all getting through alcohol? Okay, so jury number 7, why did you drive?
Because I obviously didn't feel like it was more time to drive, but I had a class online.
Right, and it's because the law does not punish people for simply having a drink and driving, right? They punish you for being intoxicated, or which is having a VAC over 0.08 or loss of innocence or equal thousand. Basically posing a threat to other people, right, or to the community. And so the question is whether a person was actually intoxicated at the time of driving. Jury number 8, what does at the time of driving mean?
Pull over? I don't know.
Yeah. Anybody have anything different?
When you're driving your car.
Okay. Oh, who said I'm operating the vehicle? You're smart. Jury number 5, what does operating mean?
Basically just using the machinery.
You know, like using a steering wheel? Okay. What if I'm just sitting there and I'm just listening to the radio and I got the air blowing? Am I still operating?
It's the vehicle's not movement, no.
So if it's not moving, you don't consider it operating?
No, I think according to the law, you can't sit behind the wheel intoxicated,
Even if it's in fault.
even if it's in port. I mean, that's the way I always understood it.
Operating view.
Okay.
On the street or in the person's side.
Even anywhere.
You're not trying to play it. You're just asking you all doing.
Can someone clarify what the law really does state? Because they say ignorance of the law is no excuse, but no one's out here teaching us the law. So how do I know if sitting behind, I don't know if sitting behind the intoxicated.
Well, for these purposes right now, we're just asking questions and folks are having to get voices. If you are chosen to be on this jury, you will get the actual law that you're. And you make a decision. Okay.
So I have a question. If they're not in Tesla.
It's self-driving. That's what I'm saying, but I guess you have to press a button to make it operate, so that would be operating, I guess, I don't know. Okay, so let's talk about something that we all do in real life. We all rely on machines and they become an important area in our life, right? What are some machines that we rely on a daily basis? Juror number 11. I'm sorry? What are some machines or technologies that you rely on? You have a cell phone or do you use maps? Do you have GPS?
Oh, yes.
Do you use it?
Yes.
Okay. Any other machine or technology that we think about that we use on a daily? Bombs. And who here believes that machines are always accurate? So we can agree that machines make us up, right? Because one time Siri told me to park and prepare to walk to my destination and it was like a lake. So I think if we can all agree that machines mess up, right? And so let's talk about,
2 minutes, Ms. Donaldson.
okay. So in this case, we have to elect to go, we elect to go to the jury for punishment. If my client is convicted, you might have to decide punishment. And you would have to consider the full range of punishment. Is there anyone here that says, on a DWI case, I do not consider probation? That's me, Rachel. Jury number 5, and jury number 5. And then we're going to end with this. So if you have to choose, which one would you be more comfortable with? Either A, letting 10 people go free to make sure that one innocent person does not end up in prison, or making sure 10 guilty people are convicted, even if that means an innocent person end up in prison. A or B? Me? Yeah. Room 2. Room 3. 4. 5.
It's like me.
6. 7. 8. 9. 10. 11. 8. 11. 12. Are you, if you have to make a decision that 10 guilty people go free so that one innocent person doesn't end up in prison, or the innocent person has to go to prison to make sure you get the other 10, which would you? You didn't hear a question?
I did, and I'm really torn on this.
Okay, it's fine. 28. Okay, 29. 30.
B.
31.
E.
32. 33.
A.
34.
A.
35.
B.
I'm not time to do it.
You can ask one more question if you have it.
I'm the judge.
Okay. All right.
Thank you.
Oh, all right, Lori, you want to come on up? We're gonna do it. Yeah. Or, oh, you mean when you call them up? Oh, no. Name. Yeah. Did you plug in already, Ramon? I didn't see. You ready?
Yes.
Okay. Yeah, at the start, I think that we can already eliminate number 11. 11. 15. 17. 30. And state, do you have any cost challenges?
Journey with Voir.
Yeah, I think we're all, yeah, okay, I'm gonna grant that. Who else? If anyone. Yeah, yeah, row by row. First row, do you have anyone else? No, second row? Sport cause. I'm gonna get to you after we do that. As soon as I get done with them, I'll ask you.
No, that's the second.
Anyone on the third one? We may not even get there anyways.
You should be with somebody first now. 35 hours. Or that's.
On next. Are you with that?
Oh,
Do you want me to write him up?
no, good.
You're good? Okay, is there anyone else?
I think when he had that meeting.
Okay, yeah, okay. Did you hear that, Ms. Thompson? Great. Are you guys okay? Yes, okay. Cool. One more. Okay, juror number 7, do you mind coming up, ma'am, please? Thank you so much for coming. One of the questions I was asked to you is if the defendant decides not to testify, they don't have to. Not everybody is well versed as lawyers, right? We go to school, we learn how to argue. That's all we like to do is argue with people. But not everybody's like that. If he decides not to testify, would you hold it against him?
Thinking why I look into yourself. And maybe it's a funny registry.
Could be, but that's why people, that's why the law is the way it is, because it recognizes that not everybody's as well versed.
Right, so I think it's lawyers would persuade him to.
Okay. You have a motion? Yeah, all right. Thank you, ma'am. I'm gonna go ahead.
Okay, all right.
Who's next? Okay. Juror number 10, do you mind coming up, please? No, but thank you for coming. So the law is such that every witness is created equal, meaning that every witness should be held on the same level playing field, no matter if it's the Pope, it's an officer, Mother Teresa, they're all held to the same standard, meaning that you are the ultimate judge of the credibility. That said, would you still hold officers to a higher standard just because they're officers, knowing that that is the law?
That's a hard question for me.
There's no right or wrong answer.
I'm a bit biased toward law enforcement.
Okay, and that's
I have
okay.
relatives that are law enforcement. So,
Sure.
And working in my field, we train people. We judge their competency to do certain things. And I think
But remember, to err is human, right? Everybody makes mistakes. No one is perfect. And that's why we have 6 different independent people to make a judgment call to see. Because when you hear someone talking, will know in your gut if that person is right on or if they're in la la land in outer space. That's why we need you to be the ultimate judge. And so everybody's supposed to be on the level playing field. When you hear them speak, at that point you can go, oh God, that guy really knows, or that person, what the hell's, what is this person? Did they just born yesterday? So that's why, but okay.
Well, obviously, I would listen to the testimony of the witness and make a decision based on what I hear. But I agree.
Did you want to question?
So it sounds like you're struggling with choosing whether or not you'd be able to set aside that biases. We have bias, and that's normal, right? For example, biases. The question is whether or not you believe that you're someone who with this trial can set your bias aside and wait to judge the officer's credibility until you hear from them.
Oh, I can, absolutely. Man, I want to hear what it has to say. Hear through.
Did you want to ask?
You can wait until the state sustained to give them credit.
Yeah, I would, but I just
And
think.
then, and then based on.
I was based on my testimony, but I also.
What was the question?
Based on their testimony, you decide that credit.
Right.
Okay, thank you.
Judge, we really got to judge.
No, I'm not going. Yeah.
Judge, you said you were agreeing.
Correct. Yeah. I'm trying to see. Yeah, okay.
Oh, it's okay.
That's really fun. Okay, who's next?
Okay. There's number 30. Number 19.
Juror number 19, do you mind coming up, please? Thank you for coming. One of the questions I was asked to you is if a person is charged in a specific county, but yet it happened somewhere else, would you be able to find, was it not guilty? Is that what it was? What was your question?
The question was if the state presented evidence that crime occurred, but they did not present evidence that it happened in Harris County, and that is one of the elements you have to prove. Would you be able to find the person not guilty?
Let me give you an example. Like, if a person kills someone in Wyoming, right, but they charged them with murder in Texas, is that right? No. Right. Well, that's basically here. They want to know if a person, they need to prove that a crime occurred at a specific place.
Okay.
You understand?
Yeah.
So that's the ultimate question here. Is
That's what I figured by the time you get to it, it's proven that's in Harris County, but.
it's still a requirement. They still have to. I mean, there's a list of elements that have to be proven, like they showed you those
Yes.
lists. One of those is that it happened in a certain place. We can't make any assumptions. We don't make any assumptions. There's no surprises. Everything is so.
For knowing that, would you feel if the state failed to present evidence of the it occurs, even if you believed it happened in Harris County, would you be able to follow the law and find that person not guilty? Okay, so you would want the state to prove every element, including the location.
But I go back to reasonable doubt. I mean, it's gonna be like when we said reasonable doubt to me, it doesn't have to be 100%. That might be one that I can overlook against. If that's the law that's against.
I didn't hear you.
Sure, so the state still has to put on some evidence.
Yeah.
So we can't prove any element that has to prove every element beyond the. And so you're saying you can fall short. Okay.
Yeah, remember, there's a certain, they have to prove 1, 2, 3, 4, 5. They can't forget to do number 3.
Yeah.
They have to do 1, 2, 3, 4, 5 in every trial, because I mean, that's the law. We like to follow it as much, you know.
Yeah.
Are you sure you can do that?
I think so. I guess that's what we're trying to.
Okay, better.
Yes.
Yes, I mean, we have to take it serious, you know? Yeah, okay. Did you want to ask anything or any follow-up? Stay? Okay, thanks. I think she's okay. I think she's okay. Sorry? No, but I think at the end she said,
She wasn't understanding. I think that, but I think she did. And she said.
I think that she's maybe a little bit confused, but I think she understands. All right, who's next? Juror number 22, can you please come up? Hi. Thank you for coming. They have a list of elements that they're supposed to prove. 1, 2, 3, 4, 5. If they forget to prove one of them, there's a certain way that you have to vote. One of those that they have to prove is where it occurred in Harris County. The question that they posed earlier was if they forgot to do that, would you vote not guilty?
I would not. I would not base my decision on the territory or the county.
Remember, when a person is charged with a crime, it has to happen somewhere, and they have to prove where it happened. That someone can't kill someone in Wyoming and get charged with it in Alaska. It just wouldn't make sense because all the laws are different and the witnesses are in different places. And so that's why we have certain guidelines that we have to follow. One of those being, and remember, in the law, there's no assumptions, there's no surprises. Everything has to be done by a certain list. One of those is you have to prove where the alleged offense occurred.
Okay, so when you were instruction and you tell me that we have to have the instruction by that list, then I guess I would ultimately vote not guilty.
Okay.
But let's switch on or off. I get it. Yes.
No, I get it. I'm with you.
No, if you instructed the jury to follow A, B, C, D, E, I'm just saying, then that's the direction the judge gave, so that's the direction the jury should take, in my opinion, whether or not we agree with it or personally or not, that's the direction the jury should follow.
Did you have them follow?
So if the judge would ask you to follow the law, in
Yes.
every element.
That's
would you
all
be-
I'm saying, like, you're the judge and you're saying you jury members have to follow these 5 checks, that's your instruction. Then follow those checks. Doesn't matter whether personally agree or not, okay?
Okay.
You have to follow the law. I get it.
Got it. Thank you, Ben.
Thank you.
Okay. What else? 22? Okay, I'm gonna write. Grant. Juror number 25, can you please come up? Hello, thank you for coming. One of the questions that was asked to you is, would you consider probation on a case like this? That's what the question was, correct? And what was his answer? No. Okay, great, thanks. All right, take care. Okay, I'll grant that.
You know, the judge was 18, who asked to be called us and be nice for his.
Okay, juror number 18, do you mind coming up, please? This was with regards to the officer. Hi, thank you for coming. So the question was asked you earlier about officer credibility and whether you would put them on the level playing field or not. All witnesses are deemed to be on the same level playing field as far as credibility is concerned. You are the judge of the believability of the witnesses. So when you hear someone testify, whether it's an officer, whether it's a lay witness, whether it's a technician like this, they're all supposed to be treated equal. But when you hear them testify, you will know, well, hopefully, using your gut, whether they're true to their word, whether they have no idea what they're talking about, whether they're out of space. This is something that you can, I guess, comply with. So you don't bring anything into here, because right, what we want is you to come in here, leave all your notions out, just come here, listen, see, and make a judgment call. Can you do that? You're not gonna put anything in.
Unconsciously, unconsciously, no, not consciously.
Well,
What could judge understanding that not every person is a good judge for every company. What we're asking you now is to let us know that it's just a sign that a person will be able to completely accept the judge's case. And that into that's the giving of it. We just need a nice switch on and off. We can do. So I switch off. Don't forget.
okay, thank you so much. All right,
Emotion.
yeah. Okay. Anyone else on the third round? Juror number 32, do you mind coming up, please? Hi. Thank you so much for coming. There are several questions that were posed to you, and we want to just know whether you were the right good juror for this case. As far as the believability of the witnesses, would you keep everyone on a level playing field?
I'm good at this.
Okay,
I make reports for people to keep quiet. And I don't make biases in here. I'll do it in the military.
and did you set all that aside and be an impartial juror? What was the other question?
So that we can judge Harris County.
Oh, so whenever someone's charged with a criminal case, right, there's a list of elements that,
In that jurisdiction.
right, I mean, there are no surprises in trials, right? They're not supposed to be surprises. Everything is supposed to go as it should. They have a list of elements that they have to prove. What the offense is, where it occurred, who the person is. One of those being here in Harris County. If for some reason, I don't know, but for argument's sake, if they forgot to prove that it happened in Harris County, can you vote not guilty?
If it didn't occur here.
No, if they forgot to prove that it occurred in Harris County.
It didn't occur here.
They forgot,
We forgot to prove it.
right? Just an oversight, just,
I think the laws in that area would be binding to prove what happened.
still have to show that it happened in Harris County.
Yes.
right?
Right.
That's just the law. Just they have to show it happened.
So I,
Sometimes people forget things.
yeah, but I think that it has to be proved that it happened or at the least for it to be.
Right,
That's
but,
law.
right, yes, and it's their duty to do that.
Yes.
But let's say they forgot to do that.
Okay, but that's their job.
But everybody's human. Something may happen, they get their mind off of something, you know, they get distracted and they
Okay.
forgot to do that part.
Yeah. Yeah.
The law would instruct you to find someone not guilty if it's not proven it happened in a certain county. Can you follow the law?
Yes.
Do you have anything else?
Nothing.
Okay, anything? Good judgment. Okay, thank you, sir. Okay. Juror number 34, can you come up, please? Okay, can you go tell her that? Yeah, and then have to come back. Did you hear that? Did you hear that? Hopefully she'll come back. Good morning. Thank you for coming. What was the question? So every single person that's testifying should be treated equally. It doesn't matter who it is. You, as a juror, as a potential juror, when you're there, we instruct you that you are the person that judges the believability of the witnesses. When you hear them testify, it's on you to decide, well, yeah, I knows or girl knows what they're talking about, or whoa, they're just outer space, have no clue what's going on. You never know what happens in trial until you go to trial. I mean, weirder things have happened, right? But it's on you to make that decision and to understand that everybody is treated equally as far as credibility is concerned. Can you comply with it? Or are you going to make an officer higher up just because they're an officer?
It's not black and white, but I wouldn't discard what the person was saying, but I would take into account what was also said.
Anything? Okay, thank you so much. All right. All right. 34, okay. And that's it, right? All right, so are you ready? Okay, we're gonna go through the whole thing right now. All right, so we've got 5, 7, 10, 11, 15, 16, 17, 18, 20, 22, 25, 30, and 34. Did I forget anyone? Okay. I'm going to call an extra person just in case. I always get an alternate. Okay, just to give you guys a heads up. Let me see, that is how many? Okay, each of you can have an extra peremptory. So that should give us enough. That's okay.
So one additional for the,
So each you get 4. Okay, so please take 5 minutes because I've been waiting a long time. So you do 5 minutes. Okay, guys, thank you for being so patient with us. I know it's a little bit of drawn out process, but you know, we really want to do things fairly. We want to do things the right way. So what we just did is they're called for-cause challenges. You know, we try to determine who is the right person for the case, who is not the right person. And remember, it's not an exact science. Some people are good for a case, some people are not good for a case. And so we try to whittle it down. And now we're at the process where each side gets what's called peremptory challenges. They get a certain number of strikes that they can use on whomever they want for nearly any reason, barring certain exceptions, of course. So I'm going to give them each around 5 minutes to make their peremptory challenges. Once they make their challenges, we're going to get their list. We will reconcile that with the for-cause challenges that we have done. After we've eliminated all those people, at that point, we will call people up here to come serve on the panel. So you can get up, don't leave, give us around 5 minutes for them to, make their decisions, and then we'll get you out of here as promptly as possible, okay? So feel free to get up and stretch, just please do not leave. And we'll try to get you out of here momentarily. Yeah.
Good morning.
Hey, good morning.
I have, you covering for another attorney. There's a motion to sub in your.
I'll sign it for you. Just have them sign.
Thank you.
Put
Have
it-
a good day.
You too. Take care. Bye.
Hey, good morning.
Mr. Peachin,
Give me 1 second, sir.
Mr. Peachin,
What's the last name?
Peachin, with a Q, Q-U-I-C-H-N,
Jail or bond?
Jim. Judge Raskin, we were gonna do an attorney, yes, this is good to you guys. He was on a jury.
Oh, right.
So, I have really, residential bit.
Yeah, do it. I mean, I'm okay with that.
So, I guess my question is does he need that on misdemeanor and felony?
Well,
Or if ours was just no cost, no threatening, harassing, cost, CW, no drugs, no alcohol. All the regular things.
What's gonna happen upstairs, you know? Wait, why are they leaving? I said not to leave. Oh, okay.
He also needs to use our
Just, yeah. Wait, no, just wait. Just wait. Just wait. You don't have to wait. We're almost done anyways. Yeah. So guys, yeah, 2 minutes, please.
Here's that, that's the felony, remember, he had the 3-year deferred, the issue was he didn't have his 2 residents.
Oh, upstairs.
Yes, because he was in custody, they did, that's when they did the,
Where's Toria? I mean, would you ask her if it's possible that felony can also use this tier act as well?
Okay.
That maybe we can kind of double up and kind of do a global resolution, so to speak, so we don't have to double up.
I was asking to state that. Okay, I'll ask.
I don't, what do you think?
I think that's the other one's a human, but I don't know.
I would like to do that. I think that that's a good idea.
I think so too, because I brought up an issue with. fees
Hey,
and changes.
Toria, So-
Causes were to be.
how do we do that though? How do we,
It's all around.
So it'll be a part of his conditions that he has to follow.
so let's do both in one, you know? Can we do 2 in 1? So we make sure it happens as well?
Okay.
Yeah. So let's do this.
So waive all our fees here.
Yes, absolutely, of course. Let's do it. And then we'll kind of put it in a holding pattern for them to do the same thing. And then we'll wait, because he's got to go upstairs to get stuff done anyways. He's no bonded upstairs anyways, you know?
He's already pled like a month ago.
We pled him forward on March 5th. This is a teacher.
Yes.
Yeah, so
That's right there. Our case was still pending. At that point, I have case was that he was homeless. It's open whenever they got up for. the report back there, that's what happened in the third one. So then they tried to plead here, and before we accepted the plea here, and one of the two rats.
I'd like to follow what the TRS does,
Okay.
you know? I think that's the best thing for him, really, considering all this.
Yeah.
So,
So will we be able to today?
yeah, let's do it. Yeah, just have him write it up. Have him write, we're done in 5 minutes.
Okay, thank you.
Miss Reed,
First one is Joya, Joya.
okay?
We were set today to complete PTI. All she has to do is take me back that class, dismiss. Long story short, she texted me early this morning, said she had to take a child to the hospital.
Every week it's something else. No,
I know.
no, every single week it's something else. Yeah, no, it gets revoked and I'm not doing anything until she actually gets here. Because it's over and it's 350. So
Yes.
10,002. Hey, come on. Okay,
You gave them a answer, but when I came in, more bond positions or different bond positions or something.
okay, yeah, give me a second. Let me finish up here and then we'll,
Yes.
okay. All right,
I think I started doing.
okay, give me 5 minutes.
Yes, sir.
Yeah.
Mr. Ledbetter, text me who you got.
And they said I was on this right.
Who? Okay, you saying we should take her on, both of them? Okay, did you guys use on a peremptory on her? No, okay, all right, so 6 as well for calls, yeah. All right, ladies and gentlemen, when you hear your name called, please stand up, grab all your stuff, and please head on over to the jury box. We'll have you just take a short seat. Or I guess.
Juror number 1, Wilkerson Sherrill. Juror number 3, Benavides Garcia Mauricio. Juror number 8, Jamerson John. Juror number 12, Kovacs James. Juror number 19, Butts Tracy. Juror number 24, Johnson Bridget. Juror number 26, Cooper Tamika.
Okay, ladies and gentlemen, the jury, if you would please stand and, or each of you can be here tomorrow morning, right? Yes, okay, I know. I'm with you too. Please, everybody, if you would raise and stand and raise your right hand to be sworn.
Do you and each of you solemnly swear that in the case of the state of Texas against the defendant, you will true verdict render according to the law and evidence to help you God? I do.
Okay, please be seated. Thank you so much for coming. We appreciate your coming down with us. I hope it will not sour your experience. Come back, please. We need your help. And I will see you soon. You're excused. Ms. Donaldson. Hey. You have a copy of the arraignment, right? I'm sorry, you have a copy of the information because I'm going to arraign him. Yes, sir. Okay, you know what to read, right? Yes. Okay. So what we're going to do now is we're going to arraign and then we're going to wait for the day. We'll start tomorrow, this morning, right at 9 o'clock in the morning. Okay. No. Let me, I'm about to arraign. All right. So, are you ready? Okay, if the defendant will please rise. Or are you, who's going to arraign?
I can do it.
Okay, are you ready?
Yes.
Okay, whenever you're ready.
In the name and by the authority of the state of Texas, comes now the undersigned Assistant District Attorney, Harris County, Texas, on behalf of the state of Texas, presents in and to the Harris County Criminal Court of Law number 5 of Harris County, Texas, that in Harris County, Texas, Alejandro Gonzalez, hereinafter styled the defendant, heretofore on or about July 25th, 2025, did then and there unlawfully operate a motor vehicle in a public place while intoxicated against the peace and dignity of the state.
The defendant now declares. Okay, you may be seated. Ladies and gentlemen of the jury, we are done for today. We have lobster and filet mignon waiting for you. Maybe, don't quote me on that, but we have something waiting for you for lunch. Please do not do any independent research. Do not talk to yourselves, anybody else about this case. I have Deputy Echegoyen here and Deputy Williams around here. They will be your primary contact if you need anything. If someone tries to come to you to talk about the case, you need to inform them. The roadmap is that you guys are excused for today. We have a lot of housekeeping duties to take care of now. I don't want you guys to have to wait and sit through anything. So we will get everything done. Have you come back here at 8:30 in the morning. When all of you guys are present, we'll promptly begin. And we're going to go until we finish. I know that your time is valuable, so I will really take that into consideration. I don't want to be here any longer than you do either, okay? So I take that into consideration, and then we'll try to be as efficient as possible. For now, I'll have Deputy Echegoyen to escort you out, and then we will see you bright and early tomorrow morning. Thank you guys so much for coming and being here. And with that, we are in recess until tomorrow. Okay.
No, I just, I would see this good spring. I don't want
I can say it's sorry, and I'm. You never know this.
Oh, you can.
It's six decades. Send it to you. You have to bring it to me. What are we
Thank you, Marty.
They bring it to us. Credit so that's fine. So it's all. Oh, and like, I should. Stay. That's a topic thing. Wasn't good. That's what it's saying. And.
I saw Diana do it, and it's like, there I was working for Yeah, functions, everything's. And I was sitting in yours because I was like, I was thinking in yours. So basically, the only one way out, they're gonna have everything in second. That's all. And I thought because he finished. And he said, I was able to put like, there's always zero that I could. He's a sheep, right?
Yeah, maybe not you.
Just laid out back in about being a I appreciate that. I hope I was bang at the job. What ultimately led you to take this profession on and exclusion? Which way did you pursue?
You know, I just have on. 18 times stacking. And within yourself, it's fine.
Yes. Thank you.
Bring it up. I haven't moved. So I've only heard it's like. Where does she want? You know, nowadays, interesting.
Any other symbols?
Morris?
I'm like. That's just. Stupid.
Morris.
If you want to do the South Park, yeah.
Thank you.
I can't see your third.
Now, I mean. Thank you. So just check that we start talking. No, not that it's hard to. I don't know.
Let's see. Let's see. Let's see.
You know, it's not. As we're looking through you, one, I'm gonna try to just sit in and get around and very fun. I also would appreciate.
Yeah.
And I just show you're kind of pausing things, so.
Put it right here.
No.
You saw me put your third alteration in front of straight right. Yes. Yes.
Stop. I don't know. So it's that.
Thank you.
I mean, they're not gonna say, they're just.
How did you like it? Have a scan.
And then I'll. Let me take a picture and then we'll.
Yes, sir.
What's good? That's not fine.
You probably want to go there,
I guess, I'll live up there, I don't wanna like squeeze it up there.
Here is a.
There you go. Perfect.
Guys ready? All right, 1, 2, 3. Okay, does anybody want to change up the pose or something? I think I go on my knees.
All right. Guys, thank
So
you.
much.
Anytime, you guys are always welcome. Absolutely. Yes. Thanks, guys. All right, let's roll, nerds. Come on.
You take a picture, Judge.
So who's your, Hewitt,
What was Hewitt?
come on up.
Judge, you know, I did that in high school and all that didn't really matter.
We probably about on a monthly basis.
Yeah.
We have
Yeah,
people come
like a serious.
every other month. Oh, thanks so much.
Your Honor, this is Ross Hewlett.
Yes, Mr. Hewlett, as a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication, not to have any contact with the complaining witness in this case. You've already seen what happens if you pick up a case. If you pick up another case, now I'm going to triple, quadruple, or quintuple your bond. Do you understand? I'm going to protect my community at all costs. If I have to put you in jail again and again, just, it is what it is. You understand? Okay. We'll have you sign a reset. You'll get with Veronica for your bond conditions. After that, you're free to go.
Thank you, sir.
Please.
Right this way.
Hold on. There is a MOAB that needs to be signed as well. Come up, one more thing. We didn't issue a protective order on Ms. Davis. I'm issuing now what's called a magistrate's order for emergency protection that identifies her as a protected individual. You cannot commit family violence or an assault against this person and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate or threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? If you violate this case or these right here, they will file an additional case against you, a violation of a protective order. That is the capital murder of misdemeanors. You understand?
Yes.
I'm not asking much from you, man. I just want you to, don't be a danger to my community. Really. All right, come on.
Thank you.
Can you re-implement the conditions that were on the DWI?
Yeah, absolutely, of course. Okay. Mr. Kitche, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. What's going on? Can't continue. If you continue the way that you're going now, you're going to end up with either a 40 or a life sentence. Do you understand? I mean, it's out of control. The idea is that we do not want to overburden you with things that you have to do. So with the case upstairs and with this case, we're going to try to combine them so they're all in one. But I want to make sure that there are no more issues in the future. What you're getting into now is you're entering into what's a deferred adjudication where if you complete successfully, there's no conviction, but you give up nearly every right known to man entering into this agreement, and you violate these conditions, I'm going to issue a warrant. You're looking at an entire year in jail. Do you understand? Yes or no?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You know, Mr. Kiche, you got to understand one more thing. If you don't have anyone in this life to pony up any kind of bond for you, every time you pick up a criminal case and end up in custody, you will be stuck like Chuck because there's no one to get you out. So when you're out in the free world, these are the things you need to be thinking about because you violate these conditions. You understand?
Yes, sir.
How do you plead to the offense, guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that. Sentence you to a 20-month deferred adjudication. No drugs, alcohol, random testing. Who is the complaining witness in this case? Okay. Is the felony is the same complaining witness? Who's
Didn't want the other one was an ex-girlfriend.
okay? Do we know whether she wants to have contact with him?
I do not.
Do we know whether she wants to have contact with him?
On our case or
No, on the felony.
No, on ours, on ours. Does she want to have,
Alright.
does she want to have contact with, I was just asking, I didn't want to make sure they're not the same. Does she want to have contact with him?
Based on my conversation with her, Your Honor, she just really wanted him to get out.
Okay, no threatening or harassing contacts with the complaining witness in this case, no weapons, and follow the TRAS conditions. waive all the fees. It's not about the money. It's about you doing what you say you're gonna do. You must report once a month. The worst possible thing you can do is either take off or pick up a new case. Do you understand? There is also an affirmative finding of family violence, meaning that you cannot own a gun or ammunition as a result of this. All right, good luck, sir.
Thank you.
Thanks. Okay, hi. So tell me about why.
Your Honor, from talking to him and his mom, something burned in the kitchen and the house got split. To be completely honest with you, when that occurred, he did take the opportunity to go back with his friends who were celebrating after prom.
Oh, so he's going out partying.
Not, Your Honor, something did occur where he could not be at the place where he was supposed to be, via your order.
Again, he's doing whatever he wants to do, man.
Your Honor, there really was a valid reason why he could not be at home.
Let's do this. I'm gonna send him for a test right now, a drug and alcohol test, and then let's reconvene tomorrow. Okay?
Now, Your Honor, bailiffs took him in.
I know, just because we didn't want to, we had a jury in here, that's why.
Oh.
We're gonna let him out. I didn't revoke his bond. I will never do anything without you being present. Okay? We
that's
just
fair.
didn't have anywhere to put him. We'll bring him out. I'm gonna send him for a test and then we'll have him come tomorrow. Yeah. Let's see how prom went.
Yes, Your
Hey, hi. Hey, good morning.
I'm here for,
Just the last name
a dinner.
with an I?
The first one on your document.
In J, I see it. Okay. Tell me what's the word?
I think I just submitted his PTI.
Okay, is there any reason why he would not,
I don't believe so, Your Honor.
is he here now?
He is, Your Honor.
You want to send him for a TRAS now? So that way he doesn't have to come back?
That would work for me, Your Honor.
My only issue is there a chance of denial?
Speaking of it, Your Honor.
I don't believe so, Your Honor.
I don't want him to do it and have to pay for it if for a denial.
0.126.
No accident?
No accident.
Okay, let's send him, you know.
Let's see if they can pick him today.
Yeah, you're right. That's way. And then, so what we'll do is we'll set you to 2.5 weeks. Got to get the interlock, pay the DA, that will pay the DA fee by the next setting. That way, when we come back, they can just follow the supervision order and he's in. Okay? We'll try to be as, we'll send for the TRAS now. The TRAS will be done in less than a week. They'll send it to the DAs. So at that point, they'll send you the contract and then you'll just have to pay the DA fee, get the interlock, and then they'll follow the supervision order. Once you send that to them. 2 to 2.5 weeks. Yeah, they're gonna send it for TRAS now. Hi. Please. Hi, Joe.
Morning, Judge. Always.
I have a client by the name of Mariana, and his mom is judge, and she has gone up to
Is this the one that we just revoked?
I didn't know that there was a solicitation. I wasn't served and Lena wasn't served, so I didn't know until after, right? And you already forfeited a bond, and so that's what.
Yeah, and I had called this morning because I was coming from Astoria and counting to let the court know that I was in Brown. My client has been detained but in Virginia.
That doesn't matter though. Like we gave her 2 weeks to go turn herself in. We even gave her an extra day. Her bond was supposed to be revoked yesterday. It's not a matter of you need to go hire a lawyer and do what you know. You're supposed to turn yourself in and we let them know that. I've told counsel now that she has until 3 o'clock to turn herself in today. If she does, and he can verify it, at that point, I'll reinstate. But I can't just continue, you know, she was supposed to turn herself in yesterday. We're now here today and it's still not done. I can't, I have to be fair to everybody and everybody I have to treat the same way. I cannot just.
Do you have a plan to Virginia to do that walk through change?
Oh, she's supposed to be there and I admonish everybody, do not wait until the last minute because Sorry.
She is, can she do what?
She was supposed to do that yesterday. And we're now here today. She's supposed to, if she goes there and books it now, she may be, I mean, I don't even know. But we've already extended her a day now, you know, really. You know, and I'll tell you for what it's worth, on fugitive cases, I usually set bonds at 5,000 plus. Hers is about as low as can be.
Yeah.
No. She's supposed to turn herself in and where she's wanted from.
Yeah, that's true. That's, we need to get her.
She was supposed to do it yesterday. Yeah, so, I mean, I don't know, is it Virginia? How long does it take to get to Virginia?
That's why I make it. But it's 22 hours.
I see what time it is.
I showed it.
Regardless, I don't think it's gonna be 2 weeks.
And the thing is she hires a lawyer the day after she's supposed to turn herself in.
What, she just gets it. No, she needs to get her money together for it. So I do have the receipt.
It's 19 hours, so it's 13 a week.
Sorry. Okay, thanks. No, I'm revoking her bond now. I'm revoked it earlier I revoked it, I set it at 0. And we gave her clear and concise instructions. She was supposed to turn herself in yesterday. We're here today. She still hasn't done it. So, yeah, just let her know that, I mean, if she gets popped, I don't know what's going to happen.
She's not. She's a mom.
Doesn't matter what, no. We have to, we treat every fugitive case the same way. We give them 2 weeks to turn themselves in. We are now past the 2 weeks and she still hasn't done anything.
Kara, John,
Sorry.
So we're trying to. Then approach it in the morning.
No, there's no approach.
There's nothing, I've already revoked the bond now. I told counsel before, if she turns herself in by the end of today, I would consider reinstating it. But past today, that's it.
Well, in the next 3 hours, because I still have to verify with.
Right, because he still has to verify it.
I'm not gonna just take her word that she's, I've had defendants take photos outside the courthouse and then run again. I verify with the jail, with the court, so it has to turn himself with someone with a badge or there's nothing else relevant. So I will verify either with the desk sergeant there or the clerk of the court. And if they can verify the previous, then I can relate to the court. And until I verify, it has no value, I'm just saying things.
Yeah. We've really had people try to take pictures right outside of a jail to say, look, I'm here.
Yep.
And then they try to verify it and they haven't even, you know, so.
Under the sun, they try to get crap, so I don't know this first one.
Bring her to court tomorrow.
What?
So that with her, surrender, then also her tomorrow morning.
No, if she turns herself in there, I dismiss my fugitive case because she's no longer a fugitive. It makes it irrelevant if they turn themselves in. So whether it's right now or 7 years from now, whenever they're inside their jail, that's when I dismiss my fugitive case. I've had ones 3 years open. They're just out there. Maybe they're in Canada. I don't know. So like, until they turn themselves in, my fugitive case stays open. Yeah.
Right.
That's what I'm saying, is when they turn themselves, when she turns herself into Virginia, once they withdraw that KPS, I dismiss my case.
Oh,
Yeah.
she needs to.
Okay. Good luck, man. Yeah, okay. Mr. Ledbetter.
Excuse Judge?
Yes, thank you.
Hey, how's it going, Judge?
Thank you for being patient.
It's no problem. I'm out here in Fort Bend, or I would have been there in person.
Are you set for trial?
We are, but
When?
April 21st.
Okay, are you requesting a continuance?
Yes, Your Honor, just a 30-day. John Paul, as you know, I work with him. He's my co-counsel on this. He's out of the country, but I
Look,
also,
Mr. Ledbetter, look,
yeah,
look, if you've not had a continuance before, I'm okay with it, but I'm only
okay.
giving you one.
Yeah, no, that's perfectly fine. We're ready to go. It's just he's out of the country, and then I have a medical procedure. So,
Who did you talk to with this, Mr. Ledbetter?
let me pull up the email.
Whose case is this? Zargo's. Hey, can I talk to you for a second? Hey, they filed a motion for continuance.
Oh, is this for,
Zargo's, are you? Okay, so you only get one though, Mr. Ledbetter, okay?
Yeah, that's perfectly fine. We're ready to go. It's just our
So
schedules.
look, I'll have you talk with Ramona. She's here online. You guys agree to a date and then, 30 days and then we'll go from there.
Okay, perfect. Thank you, Judge.
Okay, man, but this is it.
We're good. We're good.
Okay, got it.
All right, thanks.
Have fun.
Oh, yeah.
Mr. Albert. Daniel.
Yes, Your Honor.
Hey, bud.
Yes, Your Honor. I'm here on Mr. Tran Nguyen, Nguyen.
Just the last name.
Nguyen.
Oh, Nguyen. I think Nguyen, he said.
Page 20, Judge, is the judge please, are there any offers?
Taking a look right now.
What did you say?
Taking a look at it.
Oh, okay.
Well, I think Patty's already handled.
He has it. Negotiation transaction. They were holding on and off right now. Hear from them.
Selling is 5/5, the same day.
You want the same day as the felony, Mr. Albert? It's 5/5, May 5th. Cinco de Mayo.
Can I get a date after that, maybe the 8th?
I think he wants a different day. Well, you tell me what day you want.
May 8th, Your Honor.
The 8th.
Oh, that's not a good day. How about the 11th?
How about the 11th? What's that?
11 is good, Your Honor.
11. Okay, your case is old by then. I'm not going to hold it with the felony, so get cooking, Talk to them and figure it out, huh?
Oh, is that a expired hearing then?
So it's going to start where
It's 130.
it's 140, so that's another, 40 days? So you're at nearly about 180 days, so get cooking, huh?
Yes, Your Honor.
Okay, man. Yeah,
Thank you.
it's a required appearance. They're going to put an offer, okay?
Yes.
Daniel,
Yes, Your Honor.
if you want to apply for PTI, you got to have it turned in my next setting,
Yes, Your Honor.
okay?
Yes, sir.
All right, buddy.
Understood. Thank you,
Take
Your Honor.
care.
Yes, sir.
Tomorrow's when it starts. What time is it open?
Joe, you got a fugitive case?
We set it for May 4th. Well, I'm gonna offer, I'll be the trial. It's for next
Oh.
week's trial.
Okay,
Thank you, Judge.
I think we're done.
Almost done. Complication 5, single reading of
2501.
It's like, I've got overruled.
bottom of 14, except for arraignment vote to appear.
2501.
Top of 18, check in. McClatchy, Judge Jacobson.
McClaskey, come on up, ma'am. You're opposed? Yeah. You're okay. Take your time. No rush.
in school.
Did she complete it successfully? Please. Would you like a chair, ma'am? I'm sorry? But it's okay. Do you want a chair? Would it be easier? Deputy Williams, do you mind giving her a chair? Yeah, that'll be good.
Thank you.
Of course.
Just get the last name.
McClaskey.
McClaskey. Thank you so much. I appreciate it.
So normally, when people file these non-disclosures, I grant it unless the state is opposed to it. And at that point, we have a hearing to determine why they're opposed to it. Normally, people will have lawyers, so the lawyers can advise them and can argue with them, but you have filed it on your own, so.
It's a one only offense. I've never, no prior.
I understand, but let me see why that they're
Yes, sir.
opposed.
Your Honor, we're opposed because it's a crime of moral.
So, and just because of that? Yeah, I'm gonna grant it for you, ma'am. Would you like a copy?
Yes, please.
Okay, just if you want to hang tight, if you want to go back, we'll bring a copy to you. Yeah, okay? No, you can, if you want to go back over there, we'll bring you. That way it's not, because we might have inmates come out and I don't want you to be put in any kind of harm's way. Yeah, I'm gonna grant it.
Thank you so much.
Of course, ma'am.
Ready for the next one, Judge?
Yeah.
Alpha 26 Rivera, never made it back today. She was positive yesterday.
Okay, so 5001,
What about that Docket one?
is that in open warrant or?
No, she had two cases and only the VDR was filed on one case, only one case got moved to.
Okay, it's supposed to, both are usually supposed to get moved, but I guess SFBF tomorrow.
Okay.
Do you mind putting the non-disclosure?
It's already.
It's in, okay, right. Okay,
Next one, Judge, is Alpha 27, step for Raymond fell to appear.
2501. All right, we're done.
Smith, conditions.
Yes, Smith is coming up now.
Judge,
No bond, zero bond. Right. It's a fugitive case, so it's always when they don't turn themselves in. Yeah. All right, we're done.
Get your signature for the state.
Bye, Lena.